Is a short one, just for half an hour, because we thought it might be a good idea to just do some current developments in taxpayer rights from, from around the world, different places. So we have Katerina Peru, who is a postdoctoral research fellow here at IBFD. And we have Ian Young, who's the technical manager for the Institute of Chartered Accountants, United Kingdom. So take it away.
This short presentation on current developments in the protection of taxpayer rights will, it's better? Sorry. This short presentation on current developments in the protection of taxpayer rights is is a part, I need to say in advance, a part of the work on the Observatory on Protection of Taxpayer Rights that will be presented to you tomorrow by Philip Baker and Pasquale Pistone. It is an amazing project, and what I'm going to present today is just a very small part of it. So, what we chose to present now is a small or a short story of two principles related to taxpayer protection rights as it develops between two courts in one continent, and all this in the framework of the fight against tax evasion. Of course, I'm talking about Europe and the peculiarity of the European system, and as once an author put it, it's a result of the accidents of the European history that we have come up with more judicial dialogue than any other place in the world. And more than that, more than a judicial dialogue, we can talk about a symbiosis and a co-evolution. So in the next few minutes, while I will be presenting the evolution, the developments around those two principles, you will see that I'm going back and forth between the two courts. And of course, again, I'm talking about the European Court of Human Rights and the Court of Justice of the European Union, each of them responsible for the application of an instrument, specific instrument, protecting, among other citizens, taxpayer rights as well. The European Convention on Human Rights, and the Court, of course, and the European Charter on Fundamental Rights. What we have seen as they develop, as the case law develops, is that there's a lot of judicial dialogue, as I said before, between those two courts. And what we get is the result of this dialogue. And of course, you will ask, but maybe this is just a European issue, and the rest of the world is not so much interested in it. And the answer, of course, is no, because we are talking about human rights, and the way human rights is organized is the three-tiered system, where you have a global system, regional systems, and national systems, and in the end, because we have a common source for all these rights, we will have, at least we know that the intention is that they have the same content everywhere in the world. So yes, what happens here, it is relevant for other parts of the world as well because of this particularity of human rights system. Turning to the fight against tax evasion, I'm going to start by saying something that you already know, two major approaches against tax evasion, one preventive, one repressive, and the major instrument in prevention right now, huge effort by the tax administration, is put on the exchange of information. On the other side, the repressive part, we have seen that in many jurisdictions, the fight against tax evasion includes a set of very heavy sanctions, in many cases, combination of sanctions, administrative penalties and criminal sanctions as well, that are applied cumulatively. Now, these two issues have also, and you may have guessed already, impact on two basic principles regarding the protection of taxpayer rights. When we are talking about the exchange of information, I will link it with the protection of the taxpayer in the context of fair trial, and in particular with the right to a fair hearing. And when we are talking about the cumulative application of administrative penalties and criminal sanctions, you obviously will think of the principle of the ne bis in idem, or double jeopardy. Starting with the first one, exchange of information and fair hearing. What we knew until recently. I'm referring to the Cebu case of the European Court of Justice delivered in 2013, where the court stated that in the context of the exchange of information based on the directive that applied at that time in the European Union, this directive does not confer any specific rights on the taxpayer. And in particular, the directive does not impose any obligation on either state, either the requesting state or the requested state, to give the taxpayer a hearing. This approach was confirmed in a case in 2015 by the European Court of Human Rights in Strasbourg. In the Euthymia Investments versus the Netherlands decision of 2015, the court stated that yes, the exchange of information, in that case a request between Spain and the Netherlands, was in accordance with the law because, of course, it was based on the European directive. It pursued a legitimate aim because the aim is to secure the payment of taxes, and it was necessary in a democratic society. Why? Because it referred to Cebu. According to Cebu, there is no obligation for either of the states to grant any hearing to the taxpayer. What changed in 2017? In May 2017, the Court of Justice again of the European Union delivered its decision in the Berlioz case. In this case, there were two important issues concerning the protection of the taxpayer. First of all, what the court said it was that, okay, there is no reference in the directive itself. However, there is a general principle of EU law that taxpayers are entitled to be protected against arbitrary or disproportionate intervention by public authorities in the sphere of their private activities. And since there is a right, there has to be a remedy available for it. Therefore, Article 47 of the EU Charter on Fundamental Rights, providing for the right to an effective remedy and to a fair trial, applies. And the component of the fair trial is the fair hearing. And how is this now, how does this materialize in this particular case? What the court says is that the right to a fair hearing by a tribunal requires two things. First of all, that you have access to the file, and secondly, that you have effective judicial review. And each one of them is satisfied when, first of all, when you have access to the file, when you have this minimum information given to you, as described in the directive itself. Secondly, and most importantly, when we need to ensure effective judicial review, we must make sure that the court has full access to the request, so that they can assess whether this request is made in accordance with the provisions of the law. Many states in that case referred and invoked the Cebu decision in order to support their case that there should be no change in the approach by the court. Of course, there are some differences in the two cases. For example, the Cebu case concerned the taxpayer himself, while the Berlioz refers to a third party that holds information on a taxpayer. In the Cebu case, the charter had not entered into force when the request was made. That's why it didn't apply, whereas in the Berlioz case, of course, the charter applied. That's why it was judged according to the charter. In the first case, the procedure involved only tax authorities, whereas in the second case, it involved the third party that was in the middle of the procedure, and information was requested by that one. And the last, as far as the decision of the court, the Cebu case said, okay, the taxpayer does not have access to that, but it put the burden on the member states that they should provide maybe access to other parts of the investigation that are not covered by the strict rules of not jeopardizing the procedure itself. And of course, national law provides for the cases where the taxpayer may challenge the information. It was not linked to a right under EU law. In the Berlioz case, as we saw, it was upgraded to an EU general principle of law, a right that requires and demands protection under the Charter itself. Where we stand now after the Berlioz case. What I feel that we will see is that fishing expeditions cannot be acceptable because there are guarantees that someone will examine the request so that it does not degrade into a fishing expedition. Tax transparency is not absolute, so fundamental rights, such as the right to an effective judicial remedy, define its scope. And lastly, the information holder may effectively challenge the validity of an information order in cases where the absence of the foreseeable relevance is obvious, and that puts a rather high standard for challenging this information request for information orders. We are here to see how this will develop. Moving to the second part now, change of picture, sanctions, and the nebis in idem principle. Again, what we knew until recently. It was a very clear, simple rule. If the administrative sanction can be characterized as criminal in nature according to the Engel criteria developed by the European Court of Human Rights, then the nebis in idem principle applies and the taxpayer is entitled to protection. This was clear in the case law of the European Court of Human Rights, as well as in the case before the Court of Justice of 2013, Ackerberg-Franson, where it was put along the similar lines. So a member state can impose successively for the same acts a tax penalty and a criminal penalty, as long as the first penalty is not criminal in nature. That is the same rule. This case law was confirmed 2014, just a selection of cases. Again, there was a violation. The court found that there was a violation where the tax authority did not stop the procedures after the taxpayer had been finally acquitted. And also a number of Greek cases involving smuggling that caused a lot of discussion in Greece, caused the Supreme Administrative Court to change or modify its approach and still generates cases, the most recent one of them just yesterday. What changed in 2016? A major change. There was this, the European Court of Human Rights delivered the decision in the case AB versus Norway, where for the first time the court moved away from just the characterization of the administrative penalty as criminal in essence, and it put the emphasis on the temporal and substantive connection between the two procedures, the administrative one and the criminal one. And based on that criterion, it said that although different penalties had been imposed by two different authorities in the context of different procedures, a sufficiently close connection between them, both in substance and in time, was enough for them to be regarded as forming part of an overall scheme of sanctions under Norwegian law. Therefore, we do not have any more bis, we just have one. And that's why the court said there was no violation in this case. These criteria were confirmed in another decision by the European Court of Human Rights in 2017, Johanneson versus Iceland, where the court found that there was a violation of the nebis in idem principle, but why? Because there was not a sufficiently close connection or link between the two procedures. So we have abandoned the criterion of the criminal nature of the administrative penalty, and we have moved to another criterion to see how closely connected are the two procedures. Where we are now, we had a third decision, this time by the European Court, by the Court of Justice of the European Union. Only recently, March 2018, the court delivered its decision in the Menzi case, where we see a convergent approach to what has been decided by the European Court of Human Rights already. What the court said in this case was that, yes, there is a duplication of the proceedings. This duplication is a limitation of the nebis in idem principle. This limitation can be permitted only if it is justified, and it is justified when it satisfies this criteria. It pursues an objective of general interest, which is combating of fraud, VAT offenses in this case. They pursue additional objectives, so they are complementary. They are coordinated enough so that we can have this sufficiently close link between the two, and of course, they respect proportionality. I will close this presentation with two sets of comments. One referring to the substance of the nebis in idem guarantee, and the second one a little bit more to what we can expect. The first set comments is inspired by the dissenting opinion of the judge Pinto de Albuquerque in the case of AB versus Norway of the European Court of Human Rights. I have put question marks because I have not made up my mind yet. Of course, the judge himself was very affirmative in his opinion. And what he said is that we're no longer talking about an individual guarantee, the nebis in idem, because we have taken out its substance. And it has been maybe degraded to just a tool to avoid manipulation and impunity, because this is what the taxpayers were accused of doing with using this, the nebis in idem principle. The judge also said that this approach may open the door to an unprecedented Leviathan-like punitive policy, where states may arrange punishments in such a way so that they have a sufficiently close connection and they can be quite severe. And then the only guarantee that remains in favor of the taxpayer is proportionality. Second set of comments, inspired from the opinion of the Advocate General Campos Sanchez Bordona in the Menzi case, who had gone to the other direction, supporting that the Court of Justice should follow its previous case in Ackerberg-Franson, not change its position after the AB versus Norway case of the court in Strasbourg. What the Advocate General pointed out was that the interpretation of Article 50 of the Charter that provides for the nebis in idem cannot depend on the degree of the willingness of the states to comply with it. Another danger that he pointed out is that this degree of substantive and temporal connection can be very vague, and we have to assert this in every individual case. And this can cause uncertainty and complexity. And creating uncertainty and complexity, so going away from foreseeability and certainty, are not safeguarded, which are must be safeguarded according to the to the Charter. It is a problem. What he proposed was that the autonomy of the Court of Justice, when interpreting the the Charter, would allow the Court of Justice to follow its previous case law on Ackerberg-Franson, because it would provide greater protection for the taxpayer, and this is allowed by the rules governing the relationship between the two courts. Last slide. I would like to try to connect all this discussion with something that will look familiar to the colleagues from the United States, because this, this was actually the outcome of an old case, 1937, on double jeopardy, a criminal case, of course, not a tax case. But it rings a bell, and maybe we can find some connections, or maybe we can find some inspiration on how we can move from here. That was all for today. Thank you very much for your attention.
How do I get my slides?
Good question. Good question. Good question.
No.
Oh, and then let's go to here. Oh, can't get my finger to work. Right here.
Just there. Okay. Right. So as Nina said, Ian Young, I work for the Institute of Chartered Accountants, but I've been involved in taxpayers' charters for quite a long time, 10 years certainly in the UK. And can I crave your indulgence, Nina, and have a few more minutes as we're okay, so I won't keep you long from your lunch, I hope. So the first slide. No. Right, so giving my credentials, I was involved when the UK was effectively reintroducing or re-establishing a taxpayer charter in the UK, and we'd had one in 1986, and it disappeared from view in the early part of this century. So when we were discussing it, we were discussing not only the content of our charter, but also whether it should be in statute. And I know from the discussions this morning, the US has a Bill of Rights. And one thing that I was absolutely clear in negotiations with the British government was that we were certainly going to have some statutory underpinning to our UK charter, otherwise it would disappear as the previous one had disappeared. And we had some rather sort of inconsequential words in the statutory provision about HMRC should uphold the ethos of the Charter. There was nothing very specific, and we didn't actually have in statute the Charter itself. And I've been slightly, I've varied and wavered as to whether it's a good thing to include more in statute or not such a good thing. I think if your tax administration, your government doesn't want to uphold the principles enshrined in the Charter, whether it's in statute or not, you won't get a very good deal. These things are compliant. People do them because they want to do them. The authority does them because they're encouraged to do so, and they can recognise the benefits of doing it. So I'm sort of agnostic as to whether you should have it in statute and what you should have in statute. And what has been clear to me in talking about cooperative compliance this morning is that there is much more interest in tax charters, taxpayers' charters, than there was some time ago. 30 years ago, OECD was about the only international organisation interested in taxpayers' charters. We just established one in the UK, but there wasn't a groundswell, if I might put it like that, behind tax charters. And now I perceive that there is. I don't think there's still a lot of work to do, but I think in a sense, we've got the tools to make it happen. So, and I'm delighted to be involved in this. And over the last 12 months, I've been working with colleagues in the International Chamber of Commerce to produce their own charter, and I had an enormous internal argument, it would be fair to say, with the ICC people and the volunteers, the country organisations, about whether we should include obligations in charters as well as rights. And I'm pretty clear myself that you do need, tax systems have evolved, and actually there are quite a lot of obligations that taxpayers have to make sure the information is there, they comply with the rules, they do the things that are necessary to make the system work. And I think the taxpayers' charters, tax charters, whatever you choose to call them, are an important ingredient of making tax systems work better, be more efficient, more effective. I think it's good news from the perspective of both the taxpayer and the tax administration. So if I'm selling it to tax administration, I say it's good news for you. If I'm selling it to taxpayers, I say it's good news for you. But I think it really is a win-win. That's my view. And I'm going in a couple of weeks' time to the United Nations, the Tax Committee, to present to talk about tax charters more generally, but also to present the outcome of the work that we've done in the ICC. So, OECD did a practice note in 2003, and it said Taxpayers' Charter is an attempt to summarise and explain in plain language a taxpayer's rights and obligations in relation to their tax affairs, making such information much more widely accessible and understandable. And Philip Baker, who's sitting in the front row, was much more succinct when he said that a Taxpayer Charter is a short, accessible statement of the basic rights and obligations, I'm glad to say you mentioned that, Philip, of taxpayers in dealing with the tax authorities. So, the people that are involved, the European Commission produced a model of a European Taxpayers Code a couple of years ago. OECD produced their practice notes 15 years ago. OECD, Forum of Tax Administration, meets every 18 months and produces a biennial publication, Tax Administration 2017, produced information about Taxpayers' Charters. I'll mention that in the next slide. I'm also the lead on the tax advisors in Europe work on the Taxpayer Charter, and they published on the website a model Taxpayer Charter, which has the principles. Charter 4 is about the principles, so actually what goes into a tax charter, but there's lots more about what makes a appropriate and properly functioning tax system. UN Tax Committee as well, and we'll hear tomorrow morning about the IBFT Observatory on Protection of Taxpayers' Rights. So the OECD, in the Tax Administration publication, talked about rights and obligations, and we've heard about some of that this morning with the US Bill of Rights, for the taxpayer to be informed, the right of appeal, we talked about that this morning, to pay no more than you strictly should do, to pay the correct amount of tax, certainty, privacy, confidentiality, and secrecy, and obligations on the taxpayer to make the tax system work efficiently. And there were 55 countries covered in that publication. If you go to, it's only on the website, or the tables are only on the website. So if you go to table A1.124, it has the information about those 55 countries. And 32 of this, interesting as whether you define your charter in law or not, 32 of those countries, it did define it in law, 30 did it by administrative law, so soft law, but of 10 were no, they didn't have a taxpayer charter, but actually Germany was one of them. Well, they have a constitution, and they have in their legislation a de facto taxpayer charter. CFE Tax Advisors Europe, where I'm actively involved, there is a model taxpayer charter. There are 37 articles. Article 4 is about the fundamental principles, so that deals with rights and obligations. And increasingly in recent times, I don't know whether we felt timid, but we've tended to make the equal number of obligations as there are rights. IBFT we'll hear about tomorrow, the practical protection of taxpayer rights, the observatory, which I think, or certainly when IFA produced the paper was produced for IFA in 2015, there were 41 countries involved. So I think there are probably 41, there may be a few more. Chamber of Commerce, we've been working on this, and I've made available to my colleagues in the ICC all the information that is available about tax charters in the different countries and all the multinational efforts at producing charters. And we've gone for equality between taxpayer rights and tax administration. So we've fairness. We've tried to mirror the obligations and the rights. So it's up on the website, so you can look at my slides and read all that I've got, that I'm talking to today. On the UN Tax Committee, in a sense, we're asking them whether they're interested. So I've got a presentation on Monday week with a colleague from the ICC in the lunchtime break, which is 2 hours at not here today, but 2 hours at the UN system. The interpreters have to have a break. So we'll give them a presentation about the work we've put into to get to the ICC tax charter, and see whether there is an interest. There are quite a lot of countries getting involved these days. So the CFE, IFA, IBFT work, probably 60 or 70 countries are now involved. And hopefully when we make our presentation to the UN, there will be more countries that will be encouraged to adopt tax charters. So the next step, Monday week, will be at the UN Tax Committee. The CFE Tax Advisors, I'm hoping to do something, it will probably be early next year. We've got the 4th International Conference on the 24th and 25th of May in Minneapolis. It's about spreading the word. I think tax charters are an amazingly good signpost to taxpayers that they will be well treated and appropriately treated within their tax system. They're all going to be different. As Nina said in her opening remarks, every country has its own culture, its own way of doing things. You know, we're astonished by what other people do, and they're astonished by what we do. But in a sense, you have to adopt something which works for you. And certainly in the UK, my experience, I was chair of the committee that oversaw the Charter for 4 years, and I know from bitter experience that tax authorities say one thing and often do completely different things. And it's quite, although the committee was within the inside of my tax authority, it's very difficult to convince them to do anything unless they actually want to do it. You can't force anybody to do anything. Well, if you have to force them and take them to court, you've lost the argument, it seems to me. You may have a Pyrrhic victory, but I don't think that's not the way systems work. Systems work because people collaborate, cooperate to make them work and understand what they're trying to do to achieve that ultimate goal. And they're much more effective, they're much more efficient, there's less resources. If you look at my tax authority, the headcount has gone down almost 50% in the last 50 years. There are now half the number of people working there. So everything has to be much more efficient and effective than it was. So I think that's it. That's the lady economia, and I can't remember. All the different things have reasons. I think we measure things and we discern a forward path. So that's the symbol, the logo of my institute, which we've had since 1880. So we've been long in the game, but only more recently in Taxpayer Charter. So thank you very much.